America is the land of opportunity, and apparently that includes the opportunity to sue absolutely anyone for absolutely anything. From people traumatized by crunchy chips to courtroom battles over squished cupcakes, these aren't just lawsuits, they're performance art. If you think you've heard it all, oh no, you haven't even scratched the legal surface. 1. The mascot hug lawsuit. Imagine going to a game for a fun night out and leaving with a lawsuit because the mascot hugged you too hard. That's exactly what happened when a woman sued a sports team, claiming their overly enthusiastic mascot caused her back pain with an aggressive bear hug. Her medical complaint? The hug was too tight. That's right, too much team spirit, apparently. No punches were thrown, no tackles made, just an overly warm embrace. Somewhere in a parallel universe, Hallmark cards are now labeled "Warning," may cause spinal misalignment. Whether this was a genuine injury or the ultimate case of personal space violation, it's safe to say that mascots might start air-hugging fans from now on. 2. The banana peel incident. We've all seen the classic cartoon gag, someone slips on a banana peel and goes flying. But one woman decided to take that banana peel cliché straight into the courtroom. She sued a grocery store after allegedly slipping in the produce section, claiming injuries and damages. While it sounds like a scene from a slapstick comedy, the lawsuit was anything but funny for the store's legal team. Turns out, banana peels aren't just comedy props, they're litigation goldmines. Maybe next time you're grocery shopping, keep your eyes on the floor. Or consider wearing non-slip boots. Safety first, potassium second. 3. The wrong sauce lawsuit. Who knew that the wrong dipping sauce could lead to emotional devastation? One Florida woman filed a lawsuit against a fast food chain after they gave her sweet and sour sauce instead of the barbecue she ordered with her nuggets. Her claim? Emotional trauma? That's right, lunch was ruined and she took it personally. It's unclear if therapy was part of the settlement, but let this be a warning to food workers everywhere. Messing up a condiment isn't just a mistake. It's apparently a crime against humanity. Somewhere, a therapist is nodding while writing "barbecue betrayal" in their notes. 4. The yoga pants controversy. Yoga is all about balance, mindfulness, and, apparently, lawsuits. One woman filed a legal complaint against a popular clothing brand, accusing them of false advertising. Her issue? Their super stretchy yoga pants split open during a workout. If you think that's embarrassing, imagine standing in court while your case gets nicknamed the Great Leggings Letdown. The plaintiff argued that the brand promised more flexibility than the pants could handle. No word on whether she continued her fitness journey in court-appropriate attire, but at least now we know. The only thing stretching here was the truth in marketing. 5. The scary clown lawsuit. A family once sued a circus because a clown scared their child to tears. Now, granted, clowns can be creepy. We're looking at you, Stephen King. But taking the fear to court? That's bold. The lawsuit claimed emotional distress after the child witnessed a clown do something terrifying, which reportedly included honking a horn and jumping out from behind a curtain. Standard clown behavior or psychological warfare? Depends who you ask. Let this be a lesson to all clowns. Dial it down unless you want your next gig to include cross-examination. 6. The dog who wasn't a lapdog. Here's a case of expectations versus reality, Canine Edition. A pet owner sued a dog breeder after their supposedly lap-sized pup turned into an 80-pound beast. The breeder advertised a cuddly companion, but what the buyer got was closer to a furry ottoman. The lawsuit claimed deceptive advertising, though others might call it just an aggressive growth spurt. Was it a miscommunication or a masterclass in exaggeration? Either way, it proves one thing. Just because a puppy fits in your lap today doesn't mean you won't be sharing your couch and spine alignment with a gentle giant tomorrow. 7. Beer doesn't deliver. One man learned the hard way that beer ads lie. He filed a lawsuit against a major beer company claiming their commercials, featuring attractive women and beach parties, misled him into believing beer would magically improve his social life. When reality didn't match the fantasy, he sued for false advertising. His argument? Emotional distress from unmet expectations. The court didn't buy it, but honestly, someone should have handed him a copy of The Fine Print for Dummies. Reminder, If your plan to meet women hinges on hops and barley, maybe it's time to rethink the strategy. 8. The case of the invisible fence. An invisible electric fence might sound high-tech and foolproof, until it isn't. One dog owner found this out the hard way when their pooch ran away despite the pricey gadget. Furious, they sued the fence company for a product that failed at its one job, keeping Fido in the yard. Turns out the reason it didn't work? The system wasn't turned on. That's right. It wasn't broken, just unplugged. The court didn't find the argument shocking. Pun fully intended. So, next time you invest in invisible boundaries, maybe check the on switch before you call a lawyer. 9. The monkey selfie saga. If you thought copyright law was confusing, wait till you hear this. A photographer was sued on behalf of a monkey after the animal took a selfie with his camera. PETA argued that the monkey, not the human, should own the rights to the now viral photo. Their logic? The monkey clicked the shutter, so it's technically his masterpiece. It sparked global debate over intellectual property and whether animals can own art. Spoiler: courts said no. Still, it gave us one of the weirdest legal sentences ever uttered. Your Honor, the monkey demands royalties. 10. The lawsuit over bad luck. One disgruntled gambler decided he wasn't losing money. He was being targeted by the slot machines. He sued a casino, claiming they were rigged to deliver him bad luck. Not just a malfunction, bad luck specifically aimed at him. No court, unfortunately, has jurisdiction over cosmic misfortune, so his case was tossed. But hey, at least he didn't try suing Lady Luck herself. If casinos could be sued every time someone lost, Las Vegas would be nothing but courtrooms and crying tourists. 11. The college student who sued over her grade. Some students take grades seriously, but this one took it all the way to court. A college student sued her professor after receiving a B, arguing that the grade ruined her dreams of becoming a lawyer. She claimed it would derail her future career and demanded it be changed to an A. The professor, of course, stood by the grade, citing academic standards. The judge also gave her a B for effort. The lawsuit was tossed, but it serves as a reminder. If you're planning to sue your way into law school, maybe start with a better case. 12. The rent-a-goat incident. When a man hired a goat rental service to trim the grass on his property, he didn't expect the goats to develop a taste for his car's paint job. After the job was done, he sued the company, claiming the goats had caused significant damage by gnawing on his vehicle. The company's defense? We rent goats, not etiquette. Honestly, if you're hiring livestock for landscaping, your biggest risk shouldn't be auto-cannibalism. Next time, maybe just spring for a lawnmower, or at least park the car out of nibble range. 13. The mystery meat case. Dining adventures can sometimes go too far, especially when your lunch is labeled mystery meat, and you weren't in the mood for culinary suspense. One restaurant customer took legal action after being served a dish described as mystery meat on the menu. He claimed it was too mysterious and demanded a full disclosure of ingredients. The restaurant countered with, "It's on the menu, literally." It's hard to argue false advertising when the clue is in the title, but hey, maybe he expected a riddle, not a biology exam. 14. The air guitar lawsuit. Yes, someone actually sued over an air guitar competition. After being disqualified, the contestant claimed he was a victim of biased judging and an unfair audience. His air performance, he argued, was technically superior, but lacked crowd support due to sabotage. The court wasn't impressed by his invisible fretwork. Turns out, it's hard to win a lawsuit when your main evidence is pretending to play an instrument. But full points for dedication. He truly rocked the court's patience. 15. The haunted house lawsuit. Now here's a case where spooky met legal precedent. A woman in New York sued the seller of her new home for failing to disclose a rather eerie detail. It was haunted. And in a twist that would make any ghost proud, the court ruled in her favor. Yes, legally haunted. The decision was based on the seller's previous public ghost stories, which he failed to mention during the sale. No word on whether the ghosts paid rent, but apparently, in New York real estate, spectral tenants are now a legal concern. 16. The case of the loud chips. Crunching chips is satisfying unless you ask the woman who took a snack company to court over their extra crispy variety. She claimed the decibel level was so disruptive, it ruined her peaceful snacking experience. According to the lawsuit, the noise invaded her tranquility and even made watching TV impossible. While no earplugs were issued as part of the settlement, this one raised a question. Just how loud is too loud for a snack? One thing's certain, she won't be starring in any Doritos commercials. 17. The burrito that wasn't wrapped properly. Imagine biting into a burrito and having it explode like a meat-filled confetti cannon. One man didn't just curse the mess, he sued. After his burrito fell apart mid-bite, ruining his shirt, he blamed the restaurant for poor wrapping technique. The lawsuit claimed negligence, emotional distress, and dry cleaning trauma. While the case didn't wrap up in his favor, it does prove one thing. Food court has a whole new meaning when your lunch ends up in litigation. 18. The dog park drama. In a bold move for canine justice, a dog owner sued their city over a lack of shade in the public dog park. The claim? That insufficient tree coverage created unsafe and oppressive conditions for his pet, allegedly violating the dog's rights. He demanded that the city install shade structures or be held accountable for what he called heat-based discrimination. While the court didn't find this pawsuit compelling, it's comforting to know some people care enough about their dogs to take it to the Supreme Court. 19. The case of the crooked picture frame. A homeowner hired a decorator to revamp their living room, only to notice the picture frames weren't perfectly aligned. Their reaction? Not just adjusting them, but suing. They claimed the tilted frames ruined the entire aesthetic and caused emotional distress. The decorator argued that imperfection adds charm. The court likely needed a level just to judge the case. It's unclear how the damages were calculated, per degree of tilt, but it's a great reminder. Hire a decorator, get a lawyer on speed dial. 20. The $1,000 napkin lawsuit. After a messy lobster dinner at a fancy restaurant, one customer wasn't upset about the food, but the napkins, or lack thereof. He sued the restaurant for not providing enough napkins to handle the buttery chaos, demanding $1,000 for his ruined designer shirt and dry cleaning expenses. His logic? The establishment failed to prepare him for crustacean-level splash zones. Whether this was a genuine grievance or just a shellfish attempt to recoup losses, one thing's for sure, he wasn't about to let it slide under the table. 21. The case of the flying hot dog. A Kansas City Royals fan sued the baseball team after their mascot launched a hot dog into the crowd and it nailed him right in the eye. Apparently, the man didn't appreciate being served a meat missile mid-game. The court ruled it was part of the assumed risk of attending a game, just like foul balls and overpriced nachos. But now we know. At American ballparks, even the snacks can become projectiles. Morale of the story. If you see a flying frankfurter headed your way, don't blink. Catch the bun, not the dog. 22. The psychic who didn't see it coming. A self-proclaimed psychic sued her doctor after a CAT scan supposedly destroyed her psychic abilities. According to her, the scan scrambled her brainwaves and rendered her spiritually offline. The irony? She didn't see it coming. She claimed lost income and emotional suffering, but the judge, clearly not impressed by her foresight, tossed the case. Honestly, if your whole brand is predicting the future, maybe skip anything with radiation, or at least check your horoscope first. 23. The exploding yogurt cup. A man took legal action against a yogurt company after a container of their product exploded when opened, allegedly staining his shirt and traumatizing his lunch break. He argued the packaging was defective and too pressurized for safe snacking. While yogurt isn't typically known for its volatility, this guy treated it like a dairy-based grenade. Somewhere, a lawyer had to keep a straight face while saying, fermented fruit assault. And now, opening a yogurt in peace might come with a helmet and safety goggles. 24. The too warm blanket lawsuit. A hotel guest in California filed a lawsuit claiming that the complimentary blanket on his bed was unreasonably warm and caused him to sweat profusely during the night. He argued the hotel failed to disclose the thermal risk. Apparently, turning down the thermostat or removing the blanket was off the table. The case, unsurprisingly, melted in court. But hey, who knew a free blanket could lead to such a heated legal battle? 25. A woman sued Google Maps for bad directions. After blindly following walking directions straight onto a highway, a woman in Utah decided to sue Google. Her claim? The app told her to go that way, and she trusted it like it was Moses parting the Red Sea. She was hit by a car and blamed the tech, not her own logic. This might be the ultimate example of why "don't walk into traffic" shouldn't need a disclaimer. Google didn't lose the lawsuit, but we all lost a bit of faith in common sense. 26. The popcorn kernel lawsuit. A moviegoer sued a theater after cracking a tooth on a rogue, unpopped popcorn kernel lurking in his tub. He claimed they should have warned him about the potential oral hazards of enjoying their buttery snack. The man wasn't laughing during the comedy movie, unless it was through gritted, cracked teeth. He demanded compensation for dental work and emotional pain, proving once and for all that even snack time isn't safe from litigation. Maybe popcorn should come with a dental waiver now. 27. The case of the too cute puppy. A man filed a lawsuit against a pet store, claiming the puppy he bought was too cute and had become a serious distraction. He couldn't focus at work, constantly checked his home camera to watch the dog, and even missed meetings. His legal angle? The pet store failed to warn him about the puppy's overwhelming adorability. It might sound like satire, but the case made it to court, where it was quickly dismissed, likely while the judge tried not to chuckle at the phrase weaponized cuteness. 28. The case of the out-of-stock chicken nuggets. One customer took fast food disappointment to new legal heights by suing a restaurant for running out of chicken nuggets during the lunch rush. He claimed false advertising since the nuggets were still listed on the menu board. No mention of emotional damages, but it was implied. The lawsuit didn't get far, but it set a new bar for food-related pettiness. If this ever becomes precedent, restaurants might need a legal team just to manage their fryer inventory. 29. The glitter bomb incident. A man sued a craft store after he spilled a container of glitter in his car, claiming it was impossible to fully clean and demanding a replacement vehicle. If you've ever battled a glitter spill, you know, it is the herpes of the craft world. But demanding a whole new car over some sparkles? Bold move. The court didn't bite, but the glitter sure did. It probably still haunts his cup holders to this day. Lesson learned? Store your sparkles like toxic waste. 30. The ice cream truck. Jingle war. A homeowner decided enough was enough and sued a local ice cream truck company for playing their jingle too loudly. He claimed the relentless repetition of "Pop Goes the Weasel" every afternoon drove him to madness and ruined his peace. While the truck was bringing joy to neighborhood kids, this guy was plotting legal revenge with earmuffs on. His lawsuit melted faster than a cone in July, but honestly, if you've heard that song 87 times in 1 week, you might start lawyering up too. 31. The too scary horror movie case. A teenager took a movie studio to court after watching a horror flick that left him with months of nightmares and, allegedly, emotional trauma. The film in question wasn't some underground shock fest. It was a major release. He argued the trailer didn't properly warn him about the film's intensity. The studio responded with a shrug and a rating label. Unsurprisingly, the case didn't hold up, but let's be real. Suing because you watch The Exorcist before bed is like blaming gravity when you fall off a roller coaster. That's kind of the whole point. 32. The case of the squished cupcake. A customer sued a local bakery after discovering that their beautifully frosted cupcake had been squashed inside the takeout bag. Their demand? A written apology, emotional damages, and free cupcakes for life. While the bakery offered to replace the pastry, that apparently wasn't sweet enough. This case raises an important philosophical question. When does a cupcake stop being dessert and become a symbol of justice? Either way, it's probably the first time someone used the words pain and suffering in the same sentence as buttercream. 33. The Starbucks ice controversy. A man sued Starbucks claiming that their iced coffee had too much ice and not enough actual coffee. His main point? He was paying for 16 ounces of caffeine, not a snow cone. Starbucks countered with the revolutionary idea that iced drinks contain ice. While the lawsuit melted faster than the product in question, it did get people thinking. Shouldn't venti mean coffee and not glacier? The ruling clarified that common sense, surprisingly, still holds a place in court. 34. The diet soda deception. One disgruntled soda fan sued a beverage company, insisting that their diet drink didn't help him lose weight, despite months of loyal sipping. His logic? The word diet implied it was a miracle potion for weight loss. The judge, possibly sipping a regular soda at the time, disagreed. The case fizzled out, but the lesson is clear. If your weight loss plan relies solely on soda branding, you might want to consult someone who isn't a can of aspartame. 35. The case of the melting ice cream. A man sued an ice cream truck company, frustrated that his cone melted too quickly during a summer day. He claimed the company should have used a more heat-resistant formula. The defense's response? It's ice cream, not NASA-grade material. The judge didn't buy the argument, and neither did anyone who's ever eaten outdoors in July. Pro tip: if your frozen dessert is melting, congratulations, it's working as intended. 36. The case of the haunted hotel room. A hotel guest sued the establishment after claiming their room was haunted, leading to several sleepless nights and psychological distress. They cited flickering lights, mysterious noises, and a cold presence as evidence. The hotel denied any spectral activity and offered earplugs. The court didn't exactly hold a seance, but they did dismiss the case. Still, imagine the Yelp review. Room was clean, staff was nice, ghost wouldn't stop whispering at 3 a.m. 37. Sued over. Being boring. A group of high school students sued their math teacher, accusing him of being so boring that it directly caused them to fall asleep and fail. Their legal strategy? Blame the monotone. The teacher, unfazed, presented their test scores as his own defense exhibit. The case didn't stand, but it did start an unofficial debate on whether dullness could be a legal offense. Spoiler, it's not, but maybe toss in a meme next time you're explaining derivatives. 38. The helicopter parents versus college professors. In a legendary case of overparenting, a couple sued their daughter's university professors, claiming they weren't supportive enough and were limiting her full potential. The professor's crime: expecting the student to attend class, turn in work, and earn grades. Shocking. The lawsuit was dismissed, but it prompted many institutions to reintroduce a policy once known as letting your kid grow up. The professors, meanwhile, just wanted to go back to grading papers in peace. 39. The scratch-off lottery controversy. A woman was convinced she'd won $50,000 on a scratch-off ticket and sued the lottery commission when she discovered it was actually only $50. She argued the design was misleading and emotionally manipulative. The court found no fault in the fine print, just in her optimism. As disappointing as that revelation must have been, it turns out you can't sue the universe for bad luck, especially when your big win is barely enough to cover the legal fees. 40. The broken umbrella lawsuit. After her umbrella broke during a particularly aggressive windstorm, a woman decided to sue the department store where she bought it. Her claim? The umbrella didn't come with a warning about high wind conditions. The judge ruled that, shockingly, people are expected to know umbrellas aren't stormproof. Still, if this had gone through, we'd probably be looking at umbrellas with labels like not suitable for hurricanes, tornadoes, or angry weather gods. 41. The flying frisbee incident. A relaxing beach day turned into a legal headache when a sunbather was hit by a rogue frisbee and sued the thrower for negligence. The lawsuit argued that the frisbee was launched with reckless disregard for beach safety, as if they were aiming for Olympic gold in disc combat. The defendant claimed it was just a bad toss, not a criminal act. The judge ruled it a freak accident, not a felony. Still, it's a good reminder: when on the beach, always wear sunscreen. And maybe a helmet. 42. The perfect selfie camera lawsuit. A man sued a major tech company claiming their new phone camera failed to accurately capture his true essence. He accused the lens of distorting his appearance and blamed it for ruining his dating prospects. The demand? A cool $1 million in emotional damages. Apparently, blurry angles and bad lighting are now a legal issue. The court ruled that cameras don't come with a guarantee of beauty or ego protection. Lesson here? Maybe try a filter before calling your lawyer. 43. The unhappy meal lawsuit. One parent went full courtroom mode after their child received the wrong toy in a fast food kids meal, leading to a crying meltdown in the back seat. The lawsuit claimed emotional distress, deceptive marketing, and a breach of toy trust. The chain offered a replacement toy, but the family wasn't loving it. The case got dismissed faster than fries get cold, but the phrase, "not all Happy Meals are created equal," suddenly felt very real. 44. The case of the flying pizza box. In one of the most bizarre legal moves in delivery history, a pedestrian sued a pizza driver after a box flew off the driver's bike and hit them in the face. The victim claimed trauma, facial embarrassment, and an aversion to pepperoni. The driver said it was a freak gust of wind. Somewhere, a court clerk had to type the phrase "pizza box assault" with a straight face. The case was eventually tossed, kind of like the pizza. 45. The psychic who didn't predict the future. A woman sued her psychic after the reading failed to predict her divorce. She claimed the psychic gave her false hope and said her marriage was soulmate-level stable. When reality hit harder than Mercury in retrograde, she wanted a refund, plus damages for heartbreak. The psychic didn't foresee the lawsuit either. The judge ruled that fortune-telling isn't legally binding, but the entire courtroom probably needed sage after that session. 46. The time an airline got sued for being too safe. A passenger tried to bring an emotional support peacock on a flight. The airline said no, because, well, it was a peacock. Outraged, the man sued, claiming discrimination against his support animal. The crew maintained that the bird posed a safety hazard and, frankly, didn't fit in economy. The court sided with common sense. But somewhere out there, that peacock still dreams of boarding Group A. 47. A goldfish custody battle. A divorced couple couldn't decide who got the goldfish. What started as a civil breakup spiraled into a full-on custody dispute over a $3 pet. Lawyers were involved, papers were filed, judges were baffled. And the fish? Probably just wanted someone to clean the tank. In the end, the court awarded joint custody, and the poor fish got more legal representation than most startups. 48. The airplane window lawsuit. A woman sued an airline after paying extra for a window seat, only to discover the window didn't open. Yes, you read that right. She claimed she expected fresh air access at 30,000 feet. The airline argued that basic physics and the entire concept of pressurized cabins make that impossible. Unsurprisingly, the lawsuit was grounded immediately. But on the bright side, she got an aisle seat and a lifetime of ridicule. 49. The time a man sued himself. In one of the most meta-legal battles of all time, a Utah man accidentally ran himself over with his own car and then filed a lawsuit against himself for damages. He claimed he was legally liable for his own injuries. The goal? Trigger an insurance payout. The judge tossed the case, probably while questioning every career decision that led to that moment. The man didn't get the money, but he may have set a new record for personal accountability. All right, that's 49 lawsuits more ridiculous than your group chat arguments. But now it's your turn. What's the most petty, absurd, or completely unhinged thing you think deserves a lawsuit? Go ahead, light up the comments. If your answer doesn't make someone angry or confused, did you even try? And hit that subscribe button before someone sues you for having bad taste in content.